All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Sorry, court officer, could you call the case, please?
Good morning, Madam President. Situation in the Republic of Mali. In the case of the prosecutor versus Al-Hassan, Al-Abdul, Ak-Mohammed, Ak-Mahmoud, case reference ICC 01-12-0118, and for the record, we are in open session.
Thank you very much, and welcome to everyone, including those present in the public gallery today with us and those who are following the proceedings remotely, with particular thought to the victims and the affected communities. I would like to have the appearances, please. I'm starting with the legal representatives of victims.
Bonjour.
Good morning, Your Honors. Your Honors.
Honorable Madame la juge et Monsieur le juge.
The legal representative of victims team is composed of, or rather the victims are represented in this hearing by Maître Sédou Doumbia, who is following the hearing from Bamako, by Maître Mayombo Kasongo, who's following the hearing from the DRC. I won't give the location. And to my left, I have Maître Julie Goffin and Maître Anouk Kermiche, and behind me we have Madame Priske Kapinga Bieke and Madame Delice Lunga. However, in the field in Bamako, we have assistants Maître Boubacar Maïga and Madame Janine Kapinga Ilunga, who are following from Bamako as well. Thank you very much.
Merci beaucoup.
Thank you.
The Office of Public Counsel for Victims, please.
Good morning, Madam President. Good morning, Your Honors. Good morning, everyone present in the courtroom. The Office of Public Counsel for Victims is represented by Adeline Bedoucha and myself, Dmitry Supron. Thank you.
Thank you very much. Now, counsel for the defense of Mr. Al-Hassan.
Good morning, Madam President. Good morning, Your Honours, and good morning to everyone in and around the courtroom. The defence of Mr. Al-Hassan is represented today by Dr. Felicity Gary, who's participating remotely, Ms. Aka Praden, Maître Melissa Boyou-Lucier, Mr. Mohammed Al-Ansari, Mr. Ibrahim Ag-Mohammed, Mr. Shan Patel, Mr. Omar Kassar, Ms. Miriam Wabe, Mr. Ahmed Alama, and Mr. Al-Hassan is present today, and myself, Melinda Taylor. Thank you.
Thank you very much, Ms. Taylor. The prosecution, please, Mr. Duterte.
Bonjour, Madame la Présidente.
Good morning, Your Honor. Your Honors. Good morning, Your Honors. The prosecution is represented today by Madame Diane Luping, Moussa Alafi, Madame Sandra Schulters, and Paula Sacchi, and myself, Gilles Duterte. Thank you very much.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Duterte.
I turn now to the Trust Fund for Victims, please.
Good morning, Your Honours. The Trust Fund for Victims is today represented by Nicole Stark-Richter, Associate Legal Officer, Vina Suresh, Associate Legal Officer, Emma Bess and Diana Revillac, Legal Interns, and by myself, Franziska Eckermann's legal advisor. The executive director, Deborah Ruiz-Verduzco, will present the oral submissions of the Trust Fund for Victims in session 2.
Thank you very much. And representation from the registry.
Good morning, Your Honors. I will be here today alone to represent the registry. I'm Soraya Brixi from BPRS.
Thank you very much. Thanks, everyone, for those appearances. Mr. Al-Hassan, I just wanted to advise you if at any point in time during the proceedings you have any issues or concerns, please just let me know by or signal to the security officers if there's any problems. Today marks an important stage in these reparation proceedings. The Chamber will hear the final submissions of the parties and participants on specific aspects of reparations relevant in the particular circumstances of this case. This hearing provides an opportunity for the parties and participants to engage directly, orally, with the Chamber on the issues of importance from their perspective. As the Chamber has already received extensive submissions in writing, extensive observations from all the participants and parties, as well as from amicus curiae, the aim here today is for the participants, the parties, to highlight particular issues they wish to emphasize, to give detail or additional information where necessary, to clarify arguments, and to respond to arguments which may have been raised in the course of the written submissions. In particular, the Chamber considers this to be an essential moment for the voices of the victims to be heard through their legal representatives who are present here today. All of this will assist the Chamber in its determination on the reparations order. And in this context, I encourage the parties and participants to focus on the most essential points and matters you wish to bring to the attention of the Chamber and to avoid any repetition of the submissions which will be given careful consideration by the Chamber as well. We will now begin the submissions of the various parties and participants, starting with the legal representatives of victims. You have, as you are aware, 75 minutes in total. We will adhere strictly to the time frame, albeit it can be divided amongst the legal representatives of victims as you see fit. There will be a separate time frame for the Office of Public Counsel, so this is exclusive to the legal representatives of victims. So you have the floor.
Je vous remercie.
I would like to thank you, Madam President. The presentation of the legal representatives are going to be done in 3 different phases. I will open with the submissions, and then my colleague, Maître Doumbia and Maître Kasongo, they will complete from the field, hoping that the technology available will not turn against us.
Je vous remercie, Madame.
Thank you, Madam President, Your Honours, for giving me this opportunity which is given to the victims to put forward their concerns with regard to this hearing in the reparations stage. I would first like to emphasize that we are defending the interests of the victims we represent. This is something that distinguishes us from the other parties in this courtroom and explains the positions that we take, particularly with regard to the choice of reparations as well. And we would like to insist on the fact that we are speaking on behalf of the victims. We are their voice, but they are not homogeneous. They are dispersed everywhere. And the approaches aren't always homogeneous between them. The analysis of this is that it makes it possible for us to formulate concrete, realistic proposals that we hope will meet their wishes. The documents which have been submitted within the framework of the reparations procedure, as well as those that have been submitted previously, as well as our past submissions, highlight and repeat the nature of the harm suffered, as well as its extent and consequences. I will therefore not repeat all of this in detail, but we will stress the factors that we consider to be central in the adoption of the forthcoming order when it comes to answering the following two questions. Who will be eligible for reparations, and what reparations will be granted? Underlying this is the question of the number of victims of crimes for which the conviction was handed down. We are aware of the requirements set by the appeals chamber regarding the definition of the number of victims. But we also note the precautions taken in this regard by Trial Chamber 9 in the Ongwen case. Such a requirement cannot be imposed to the detriment of the victims and in an unrealistic way. Experience has shown that it is impossible to precisely determine the number of victims of crimes covered by the conviction. This determination remains furthermore autonomous and separate from the implementation process, which alone will make it possible to identify the portion of victims who will be the beneficiaries of the reparations. And in this regard, there are two realities with which we are faced. The first is that the entire population of Timbuktu was persecuted. There's no need to repeat the passages from the judgment on the sentence and the decision on the re-examination of the sentence that establishes this. This means, on average, 50,000 people on the basis of different assessments of the parties and participants. And the second reality that has to be taken into account is that it is essential that the reparations requested be realistic so that they can be implemented. As such, it is necessary to take into account the number of victims who will never participate in the reparation process, either because they have not expressed their will so to do, or because they cannot be reached. We therefore consider it reasonable to refer to the assessments of the registry, which would indicate that reparations would only be sought for 15,000 people in all categories. This estimate corresponds to the findings we were able to make during the too few missions that we were authorized to conduct. That is why we are trying as far as possible to adopt a realistic approach based on concrete data, which will take into account the budgetary constraints facing the court, while at the same time responding to the real needs of the population. With regard to the first two questions mentioned above, I will now turn to the issue of eligibility. With regard to the question of who should be recognized as beneficiaries of reparations to be ordered, we are, of course, bound by the terms and limits of the judgment. However, the specific nature of the case leads us to consider a dual-fold issue, namely, one, the scope of the crime of persecution in quantitative and qualitative terms, and secondly, the fact that with regard to the other crimes covered by the judgment, the court recognized among the entire population of Timbuktu during the period that was covered, they only recognized 49 victims of torture, other inhuman acts, cruel treatment, attacks on dignity, condemnation without trial, and mutilation. And it has to be noted that nearly 90% of these 49 victims are men. Firstly, with regard to the crime of persecution, reparations should be aimed at the entire population of Timbuktu, and more specifically at all those who were present in Timbuktu at the time of the occupation, including those who left the city because of it. The crime of persecution is of particular importance in this case. First of all, the nature of the persecution is notable, and its multifaceted nature is impressive. The difficulty in this case is not to establish a list of the fundamental rights of which the population of Timbuktu was deprived, but rather to find the rights of which it was not deprived. We have not identified any. Even rights whose deprivation may seem almost insignificant, such as the right for young children to play football or listen to music, they were prohibited. Furthermore, the fact that the acts underlying the crime of persecution do not constitute crimes under international law should in no way influence the assessment of the seriousness of the crime itself. This gravity stems precisely from the spectrum of violations and the lasting impact of the restrictions imposed on absolutely every aspect of daily life, which resulted in a veritable ban on living. The collective aspect of persecution, on which we have already commented, takes on a particular significance in the case of Timbuktu. The social cohesion was destroyed by obstacles in the future, and it's fundamental that any order in the future replies to the need to have recognition of persecution, which was both collective and it was also targeted individually on every inhabitant. It therefore has to grant modalities which are appropriate, such that the harm suffered can be addressed in its component aspects. Furthermore, the occupation as it happened in Timbuktu in 2012 to 2013 necessarily led to the emergence of the phenomenon of transgenerational transmission of harm. We will not revisit the principles relating to the recognition and determination of this harm, as was established by the court, or has been established by the court since the Katanga case. But in this case, in the field, we have been able to observe in the field all the conditions which are conducive to the development of this harm, particularly through our moving interviews with relatives who were clearly suffering from post-traumatic stress disorder and who described a situation in the upbringing of their children that clearly revealed the transmission of harm between generations. And that's with regards to parents who are clearly suffering from post-traumatic stress. I now turn to the question of the other crimes for which Mr. Al-Hassan was convicted. We note that the sentencing decision interpreted the judgment as limiting the victims of these crimes to a small number of individuals. And as such, we would like to stress the incomprehension and the sense of injustice that such an interpretation creates among victims. The debates have revealed a huge number of victims of acts such as torture, attacks on human dignity, and other inhumane acts. And here we refer to our observations regarding the results of our interviews with a number of these victims and to the conclusions to be drawn in terms of eligibility. The granting of specific reparations for the above-mentioned crimes committed against these identified individuals on the basis of documents or reports whose clarity and probative value are questionable is a source of concern and is questionable. However, some of these victims who confirmed the incidents referred to in the judgment do not, however, recognize the documents on which the Chamber based its reasoning and have expressed doubts about their accuracy. Furthermore, most acts of torture and other violations of physical or moral integrity were perpetrated in conditions that were traumatic for the entire population. The occupiers, above all, tried to create terror through public floggings with one objective, that of maintaining order. And in this regard, we note that in the instant case, this issue was addressed during the preliminary phase, pretrial phase. The Pringle judge of pretrial chamber 1 concluded that persons who witnessed crimes committed against other members of the population may be considered victims who have suffered psychological harm. More importantly, the Ntaganda Reparations Order settled this issue in its paragraph 128. The Chamber recalls that in the sentencing judgment it concluded that in certain cases crimes may have irreversible consequences, not only for the direct victims, but also for persons who have witnessed the commission of those crimes. These indirect victims may also be entitled to reparations, provided that they demonstrate, in accordance with the applicable standard of proof, the personal harm that they have suffered.
We consider that these conclusions should be applied here to all persons who witnessed the commission of crimes against the identified individuals. Among these victims, there is a victim of mutilation, which took place in Sankore Square. At least 2 other witnesses for the prosecution were victims of flogging in the same square in the presence of children. We also spoke with 2 other individuals from this group who were flogged in public and who witnessed a large number of people gathering at the time the sentence was carried out. As a result, all individuals who witnessed the punishments should be acknowledged as victims eligible for reparations. The trauma and psychological consequences are even more evident for all these people, to the extent that every witness to these acts understood that they could be next and subjected to the same treatment. I refer to paragraph 45 of the sentencing decision. In conclusion on eligibility, and this must first and foremost cover the entire population affected by the crime of persecution, and let us not forget the clarification that reparations will likely only reach a portion of this population. With regard to other crimes, we are of the opinion that the order will only be able to meet the requirements for appropriate and meaningful reparations if it includes all of the indirect victims of the crimes, as we have just defined. I now turn to the question of the modalities of reparation. We note the semantic discussions around the various categories of reparation and the terms, the collective, individual, collective with an individual component, community, symbolic, etc., etc. But for a given victim, what is of importance is knowing what the promised reparations consist of and how they will assist them in moving forward in their lives, regardless of how they are classified. In our various filings, we have outlined the various forms of reparation that correspond to the wishes of the victims. We were of the mind that they could reasonably be part of a reparation program into which these forms would be integrated in one way or another. Of course, when a population finds itself quite literally stunned and immobilized by terror, by a regime of terror, economic and social recovery is all the more important, as it will assist in restoring the mechanism of trust and collaboration that will prove essential to any community. In such a context, the courses of action obviously take shape in social activities, in education, and the restoration of the economic fabric through all forms of support for income-generating activities. When asked about what their wishes were, the victims we met talked mainly about support for income-generating activities in the fields of, for example, agriculture, agri-foods, and crafts. The forms in which these activities are envisaged have a strong collective component, and in some instances they refer to a mentoring system which would integrate social and training components. All the avenues indicated by the victims point to collective projects which seek support in order to be relaunched in a solid manner. I don't think I have time to go into the details about the Peace Garden, which is of particular interest, but the number of direct and indirect beneficiaries is sufficient to justify the relevance of such form of support in the reparations to be granted. The revival of this garden through planting activities directly affects several hundred people and indirectly affects several thousand. Our visit to the site enabled us to assess the existing skills and the infrastructure present and the simple measures that could be taken to improve and make the existing system profitable. In addition, combined with the revival of activities around the Peace Monument, this indirectly targets a significant portion of the population. The same applies to agri-food production and various craft activities in which Timbuktu has particular expertise, and the specific features of which we have outlined in our observations. We believe that if there is a targeted support in various complementary areas of activity, it is realistic to expect that there will be repercussions for the entire population. There should be a specific modality for those people who are non-Muslims and who were affected by lootings and destructions. We also need to think about the reconstruction of the social fabric and matters of cohabitation and cohabitation between communities. We suggest that we develop this point when the Chamber puts their questions to us. One last wish that we would like to transmit on the part of the victims. They are requesting reparations that apply to their situation in their file and not an al-Mahdi bis. Now, let me talk about symbolic reparations in the form of a payment. We take note of the observations from the OPCV, which sets an amount that would be intended exclusively for direct crimes, for direct victims of crimes other than persecution. For our part, we would like to advocate the adoption of an order granting a symbolic amount to all eligible victims. And with this idea in mind, we would like to submit a few ideas to the Chamber to consider. From our interviews with the victims, they said to us, both those who remained in Timbuktu and those who were displaced out of the city, that they thought that they would be able to start an AGR under good conditions with an amount of money ranging from 250,000 CFA to 300,000 CFA. So, we suggest that the Chamber do not go below this threshold, that is to say, approximately 400 euros. Were the Chamber to contribute this reparation, we believe it would be appropriate. This symbolic amount should be awarded on the sole basis of the victims' demonstration of their membership of the community targeted by the crimes. Now, I'd like to talk about the prioritizing implementation. Of course, we need to take into account the age, gender, and physical and mental health state of the victims. This must be properly assessed, taking into account the situation of the victims to date and their degree of vulnerability at the time of implementation. We would also like to direct the Chamber's attention to another criterion of priority, which we would think would identify ways to accelerate effective implementation. We want to emphasize the dynamism shown by women in the Timbuktu economy and the way that they provide for the needs of their families. Last of all, we would also admit that it would be appropriate as a priority to take into account those victims of persecution who have suffered particularly serious and harmful underlying acts. In practice, this could cover victims identified on the basis of vulnerability criteria. By way of conclusion, Madam President, Your Honours, as you will have understood, the victims have high expectations of this order, and it will be after a very disappointing judgment for them. So they are pinning their hopes on obtaining reparations that will meet their concerns and the wishes that we share, without there being any peripheral issues such as the manner in which the crimes were committed, undermining them in any way. Thank you very much.
Merci beaucoup.
Thank you very much. I would like to hand the floor over to my learned colleague, Maître Mayombo Kasongo. Oh, it's Mr. Seydou Doumbia now, first of all, and then Mr. Kasongo will come and wrap up. Thank you. Mr. Doumbia, please.
Monsieur Doumbia, you have the floor. Mr. Doumbia, you appear to be muted. Please unmute.
Oui.
Zita, oui.
Madame la juge présidente, j'avais
Yes, Your Honour, I noted at an earlier stage that Mr. Kasongo was ready to intervene, so I think that Maître Kasongo can take the floor, and Maître Doumbia in the interim will do his best to connect in order to take the floor at a later stage. Thank you very much. Mr. Kasongo, please.
I'm sorry, but there's no sound. Oui.
Est-ce que nous sommes bien ensemble? Est-ce que vous m'entendez?
Can you hear me? Yes, we can. Thank you.
Merci, Madame la Présidente.
Thank you, Madam President.
Merci, Madame la Présidente.
Thank you, Madam President.
Je vous présente
I would like to present the views and concerns of victims at this stage of the proceedings and provide the information given by my excellent colleague, Maître Sita, who I would like to thank enormously for having shown the table of all our concerns throughout this stage of the procedure. And it is with particular concern of obtaining reparative justice that I will not spend an overt amount of time over what has already been said, but quite simply add certain precisions there too and clarifications there too. I will also mention other points of interest to us such that you may understand the essential elements of my remarks. Jean-Patrick Musenga Kalambai, who is Congolese, wrote an important text on the definition of victims of war, and he addresses a question which is quite close to that we have, and he says that it is following fear of displacement and the loss of property that the displaced person falls into the trauma and suffers. Displaced persons, as they say, these are internal displaced persons who are displaced from one place to another through fear of persecution or reprisals. And to that I would add an important element there too, and that is the category of victims that I have met, approximately 1,000 people, and they move between the area called Trois Frontières, or three borders. And in this area of Trois Frontières, it covers Burkina Faso, Niger, and Mali. And the Chamber wanted to know, in its questions, the way in which your Chamber could attenuate the risks that there are when giving a reparations order for the security of the information of the beneficiaries. And that is a question that has been of concern to me when it comes to adding to the explanations which my colleague has already given. In other words, when I was proposed to have a system to attenuate or mitigate the risk with regards to the security of information in the framework of reparations, I would like to point out to the Chamber that there is a risk to victims' security, and more precisely, the victims of this Trois Frontières zone, because they have to move about between Ouagadougou, Bogo-Dioulasso, Niger, Bamako, and Timbuktu, and they move quite frequently between the two, and they go back and forth, and their security cannot be guaranteed. And there is a lot more security with regards to the information that can be disclosed in the reparations order, because quite simply, the public nature of the debate imposes this, because quite simply the order can be classified as public, and as such our concern is to point out that there is indeed a risk. I opted for an approach with these victims in this Trois Frontières zone, and I will give you some answers with regards to the victimization and the expertise which is ours as legal representatives of victims. Now, firstly, the victims think that living in a community will or should give an element of confidence and trust between the beneficiaries themselves, between the beneficiaries that have been identified within the proceedings, because the proceedings can well exclude some people. As such, these people could react badly to the situation. Now, where it concerns the legal representatives, the Chamber must look at the trust fund through its reparations plan such that it presents the concerns when reparations are ordered. Now, the Chamber can call in its order, as has been observed already during the reparations stage, it as the account of the treatment, individual treatment of requests, individual requests are found. And as a corollary to this principle, the notification, direct notification of victims and intermediaries to reduce this means that the victims are to be informed about their situation. whether they are candidates for reparations or requesters of reparations. Now, the Chamber can exercise its right in ensuring that any information which goes against confidentiality can be redacted in communications with or on individual decisions or when providing individual notifications. And in this way, the Chamber can, in a paragraph, put forward a principle according to which the parties and participants are invited to observe the principles of confidentiality, and in particular by reducing the number of these people inaudible.
Par exemple, par la réduction d'actes
For example, by reducing other acts of mediation between the organs of the proceedings and the victims, orienting the victim and the beneficiaries, guiding them in order to stay in permanent contact with the office of the trust fund. That is for the proper receipt of compensation in a secure manner. The Chamber can also ensure direct communication with the requesters who do not have representation, and that will also reduce the formalities associated. And an example of the special formalities could concern this aspect when the parents can no longer act in an easy way and they have, or if they have a member of their family or a relative in their family is affected or not concerned with the reparations process. Exceptionally, we can admit that victims have a member of their family who can look after them. And as we have seen in the past, if it is not a candidate for reparations, then the information that is provided makes us realize that there are two people who have requested reparations. So this precaution or formalities is prudent, or to ensure formalities is prudent to ensure that security of the reparations is assured. Now, with regards to the question of the information, the legal representatives consider, or when it concerns the redacting of information, we consider that you can't redact information which was already public in public orders. Nevertheless, the legal representatives propose that there is a distinction made between information which names the people concerned and individual information which can guarantee a right to reparations on an individual basis. And here we have the obligation to protect those people. Having this distinction with other information in a general way, that means that it's general information and collective information which concerns the victims as a whole. Where, for example, the life of the victims, they are part of a large family and they are eligible to be a beneficiary. They don't proceed in the reparations proceedings, however, although their right is recognized. Now, in this case, the Chamber can carry out this notification or this guarantee to ensure it is assured for this victim. Now, another example that we have seen in the past means that a policeman who has provided a request that has been accepted has the reservation with regards to the disclosure of information. Now, it could be ethnic identity. Such people can benefit from individual reparations. If this right is not guaranteed, there is a potential risk to security and with regards to their profession. Inaudible.
De confidentialité, des précautions qui vont.
With regards to precautions that need to be taken for confidentiality, they need to go beyond simple guidance for cross-border victims because for their work in the Trois Frontières area between Bamako towards Niger or in Burkina Faso towards Mali. Now, these victims form a group of families who want to carry out family visits as well. They want to keep up with the family traditions. I've spoken about returning to their living, the life, the family life of the extended family in their traditions and their diversity and their religious and ethnic conception thereof with regards to the traditions of the elders. That is also when it comes to parents of victims, direct or indirect victims, who have the right to travel in order to meet their needs to do so. And that is the reason why the legal representatives of victims respectfully put to the Chamber that there are these avenues for reflection when it comes to the coming order. When it comes to the criteria that the Chamber will choose, according to which it will assess these elements. Once they are taken into account, the question that remains is to know if these victims accept a type of pardon which could come from Mr. Al-Hassan himself. And what do I mean by that? There are a sample of 1,000 victims. They are a large group, if you like. If you want to divide them into 3 groups, the group of women, adult women, and you have adult men, and the group of children. If they accept an apology from Mr. Al-Hassan, if he himself, and according to their expressions, if he could make an apology which is written or oral and play a role at his level to reiterate the non-repetition of what has been done in the past, namely the occupation of Timbuktu. I'd like to stress that because it is an expression by having apologies, but the sentence that was repeated to me several times is that of saying, above all, do not do that. Otherwise, we are legal representatives of victims. We are the voice of victims, and what I have reported to your chamber is the expression of this majority of the victims who consider that they do not want to hear a light apology, but they at least want him, Mr. Al-Hassan himself, through his actions or through the way he does things, to make a commitment, written or orally. And this proposal in this regard will be something that would calm tensions between these victims. And there is tension between Mr. Al-Hassan as well, who one day will return after the end of his sentence. his community among his community among these people, so these proposals that are made to calm the tensions for Mr. Al-Hassan and the victims, that is something that would be the most appreciated. And finally, I will have spent a lot of time on different aspects, but I would like to thank my colleague Maître Doumbia, who's going to complete after me, but I think that my colleague Nsita already addressed all the different issues concerning the form of reparations. However, I would like to add another element, and perhaps one which isn't particularly lengthy, and that is that where you have the division or the subdivision or the regrouping by age of vulnerabilities and geographical location, that might make it possible to ensure that these victims are treated and identified by different categories. These geographical criteria are not far from the geographical area, and we have always worked with those to enable us to meet the mass of victims. I would like to thank your chamber, Madam President, your honours, all the victims that I have met. Thank you for this time. And I have finished.
Merci beaucoup, Monsieur Kasanga.
Thank you very much, Mr. Kasanga. Now, Ms. Nsita, what is the situation with Mr. Doumbia? Mr. Doumbia, I believe that Mr. Doumbia can intervene now, but if there are any outstanding issues, we do have his speaking notes. So if that does arise, we will see whether one of us here present in the courtroom will be able to present for him. But otherwise, I think he's up on the screen now. Thank you very much.
Monsieur Doumbia.
Hello?
Hello? Good morning, Mr. Doumbia. We can hear you. You can start, please.
Monsieur Doumbia, vous pouvez commencer.
Mr. Doumbia, you can start.
Bonjour, Madame le Président.
Mr. Doumbia, good morning, Madam President.
Madame, Monsieur,
Ladies and gentlemen,
honorable juge,
your honors.
je suis très heureux ce matin,
This morning, on this solemn day,
de porter la voix
I have come to bear the voice of the victims, these numerous victims
qui restent rongés
who
par la souffrance
remain,
et qui s'entendent
who continue to suffer and who can hear us from so far away, but also from so close.
en faisant mienne l'ensemble des plaidoiries de mes très estimés
When listening to
très brillants,
my very brilliant and esteemed colleagues, I would now like to intervene with regard to 3 points.
d'abord
Firstly,
les échos terrain,
the feedback from the field.
ensuite
Then I would like to talk
par les représentants
about the difficulties encountered by the legal representatives for victims, the challenges that they encountered on their mission in relation to the reparation process. And then finally,
la mise en œuvre sur des réparations
the implementation of the reparations process on the territory of Mali.
Premier point donc,
So my first point
les échos du terrain
regards feedback from the field
comme étant le cri de cœur des victimes.
inaudible.
Les échos du terrain traduisent un sentiment positif et intense,
This
doublé d'une demande
conveys
de la part des victimes.
message from the English booth. The echo is very distinct and it's very difficult for us to interpret under such circumstances. We will try. The following anecdote
Le cri de cœur
clearly
des victimes
conveys the heartfelt cry
d'aujourd'hui.
of the victims who were awaiting today's hearing.
Lors d'un entretien récent
During
au sujet de la
a
présente audience,
recent interview about this hearing, a victim said to me,
Maître,
Counsel,
croyez-vous que
do you
lors
think
de ce procès,
that something
quelque chose de potable
worthwhile
pour les victimes?
will come out of these trials,
À la question ainsi posée,
of this trial for the
j'ai
victims?
répondu par une autre question.
I responded to this question by putting another.
Avez-vous de bonnes raisons de croire
Do you
qu'il n'en
have
sortira pas quelque
any
chose
good
de
reason
potable
to
pour
think
les
that
victimes?
nothing worthwhile will come out of this for the victims?
Et il a répondu.
To which he responded.
Le fait est que nous avons trop
He
souffert
said, the fact is that we have suffered
et souffrons toujours.
greatly and we continue to suffer.
La mort
Many victims have died
et la peine pour demain.
and peace is not
Nous espérons
on the horizon.
et restons confiants
We still have hope
que justice
and
sera rendue.
remain confident that justice will be done
Personnellement,
for the victims.
j'ai juste besoin de recouvrer
Personally,
mon
I
honneur et
need
ma dignité
to
humaine
regain my honor and my dignity
en reprenant
as a
mes
man
activités d'embauche bovine,
by resuming my activities,
plus d'être à la charge
my
de quelqu'un.
cattle farming activities. I don't want to be a burden on anyone anymore. Another victim said the following to me:
Ce qui est fait,
what's done is done.
l'occupant a sacrifié Tombouctou
The
avec ses hommes,
occupier sacrificed Timbuktu with its people, its values,
l'histoire,
its history,
sa dignité,
its dignity,
son présent et
its
son futur.
present and its future.
Tombouctou doit renaître de ses cendres,
Timbuktu
physiquement
must rise again from the
et
ashes,
tout le reste.
both physically, morally, and in every other possible way. End of
Ces mots
quote.
traduisent dans une large mesure
These words, to a great
les
extent,
aspirations et les
reflect
attentes profondes
the
des victimes.
aspirations, the deep aspirations, and the expectations of the victims. First of all, they would like to be able to recover their honor and dignity as human beings. First and foremost, this requires a solemn or the solemn reaffirmation by international justice of their status as victims of the occupation of Timbuktu from 2012 onwards, which in itself is a symbolic form of reparation that they could benefit from, whether they be direct or indirect victims, whether they be identified or unidentified victims. And then there would be other possible and conceivable forms of reparation that would follow. Mr. Nsita talked about this, and we have lengthily discussed these matters. I shall not come back to them now.
Le deuxième point,
Now, the second point that I would like to raise
c'est les défis rencontrés par les
is
représentants
or
légaux
are the difficulties
dans
encountered
l'exercice
by
de leur
the
mission
victims' legal
en lien
representatives
avec le processus de
when they
réparation.
were carrying out their mission associated with the reparation process.
Au nombre de ces défis,
Amongst these challenges
nous présentons seulement deux.
are inaudible,
Les restrictions
namely
liées à la
the
situation
restrictions
d'insécurité qui n'a pas
associated
permis
to
d'effectuer nos missions
the
souhaitées,
security which prevented us from carrying out our
de la masse des
desired
victimes se trouve
missions,
étendue du territoire
and also the
ailleurs.
fact that victims were scattered across the entire territory and
D'abord, les
beyond.
restrictions liées à la situation d'insécurité
Firstly,
qui n'a pas permis
restrictions
d'effectuer
associated
nos missions
with
demandées.
the insecurity prevailing, which stopped us from carrying out our requested missions.
Nous notons qu'à Tombouctou,
In Timbuktu, it should be noted
par les
that
représentants
access to victims by the
n'a pas
LRVs
été à de souhait.
was not as extensive as we wanted. And there were only 2 missions that
Mauritanie,
were possible.
là où il y a
In
une forte
Mauritania,
concentration de
where
communautés
there is a large concentration of a community coming from Timbuktu, living in refugee camps and elsewhere in the country,
l'accès aux victimes
the
n'a pas
access
été
to the
possible
victims was not possible
à
due
cause des
to
restrictions de dernière minute
last-minute restrictions that
imposées
were
par les autorités en charge de la
imposed
sécurité dans
by
ce
the
pays.
authorities in charge of security in the
C'est
country.
malgré l'implication forte
And this was
du
despite
Haut Commissariat des Nations Unies pour
the
les
heavy
réfugiés.
involvement of the UNHCR.
Au Niger,
In Niger,
là où la concentration des
where
ressortissants de
there
Tombouctou
is a great concentration of Timbuktu nationals who were victims of the occupation, the only mission authorized was carried out
dans les conditions extrêmes
under
d'obtention de visas
extreme conditions
et même d'accueil des victimes.
because it was difficult to obtain visas and it was also difficult to access victims.
L'éparpillement en masse des
Then,
victimes sur toute
let us
l'étendue
talk
du territoire.
about the scattering of the victims across the entire territory.
L'éparpillement des victimes à travers
The scattering of victims across all of the regions of Mali, but also across many other countries,
représentants légaux des victimes
proved for the LRVs to be a real impediment and
le maximum de victimes.
prevented them from identifying the maximum number of victims.
Les victimes enregistrées
The number
par les représentants
of
légaux des
victims registered by the
sont
LRVs
bien plus nombreuses
is much higher
que celles dont
than
la demande de participation a été
the
soumise à
number
la
of
Chambre
applications for participation that were submitted to and accepted by the trial chamber.
Le nombre de victimes
The number
reconnues
of recognized or acknowledged direct victims, that is to say 49 victims recognized by the chamber, is insignificant compared to the number of direct victims listed by the
par
LRVs
rapport
and
celles
compared
qui n'ont jamais été identifiées.
to all those who have not been or could never be
Le
identified.
jugement de la Chambre en date du 26 juin
The judgment
2024
of 26th of June 2024 of Trial Chamber 10
des crimes
found
d'humanité
Mr. Al-Hassan guilty of 8 counts of crimes against humanity and war crimes.
reconnu
The chamber also
qualité de victime de persécution
recognized
à toute la population
that the
vivant
entire
à Tombouctou
population living in Timbuktu
à l'époque de la commission
at
des
the
crimes
time of the commission of the crimes
de Al-Assad.
charged against Mr. Al-Hassan, that they were all victims of persecution.
La question qui se pose est celle de
The
savoir
question that now arises
comment
is
réparer
how
tant de préjudices
to
subis
compensate for so much harm suffered by so many people in Timbuktu. These matters have been discussed on many an occasion and in various submissions to the Chamber, and we would call upon the Chamber to refer to them. We should highlight once again the challenges so that the Chamber's order on reparation takes them into account when defining the nature, the scope, and the modalities of the reparations. My third point, the implementation of the reparations process in the current context in Mali. And this is a sensitive matter. Everyone is aware of the fact today that the current context is full of threats. There have been renewed terrorist attacks throughout the country, throughout the Malian territory. And in this regard, I will not be telling you anything new, inaudible, because the world today is inaudible. Currently, it would not be exaggerated to say that no locality from east to west or from the north to the south is really safe from terrorist attacks in Mali. And as a result, it has become very difficult to access victims for the reparation process. The legal representatives for victims submit this matter for it to be taken into account when a decision is taken and when the reparations are implemented. Secondly, there is also the fact that the prospect of the ESA countries withdrawing from the Rome Statute. The LRVs have learned from the media that these countries are preparing to withdraw from the ICC in order to create a Sahelian court. Although it may seem premature to discuss the impact of such a possibility, however, were this to happen, it would have an impact on the progress of the proceedings, of the reparations proceedings at this stage of the case. Nevertheless, it is worth considering this prospect for the future and talking about it with regard to the Al Hassan case. However, such a withdrawal should not have inaudible on the reparations process. We could imagine, for example, a monitoring system between the two systems, the two judicial systems, in order to ensure that the implementation plan adopted retains its adaptability in order to react appropriately to any such event. Madam President, Your Honours, I would like to reiterate once again that the victims that we represent are expecting a great deal from you. They are expecting a great deal from you because today they are quite simply waiting to be rehabilitated. And such rehabilitation can be conducted inaudible, can be conducted with funds. Rehabilitation can happen when we show people how they can best live together. And today, the legal representatives of victims are submitting their concerns, their expectations, so that the hearing on the reparations can take into account all of their concerns. And I thank you very much indeed.
Merci beaucoup, Monsieur Dumbia. And I understand that concludes the submissions of the legal representatives of victims. And thank you very much for adhering to the time frame. We will now, at this juncture, we're a few minutes early, but we will take the morning break, and we'll return to commence with the Office of the Public Office for Victims after the break. Thank you very much. We'll reconvene at 11:30.
All rise, veuillez vous lever.